How does a person commence civil litigation? Well, here we're looking at commencement of proceedings, so it's worth remembering what a proceeding is. You'll hear practitioners conflate the term proceeding in the singular with proceedings in the plural sense, including myself. But Justice Leeming reminds us that a proceeding is just some method permitted by law for moving a court or judicial office to some authorized act, or some act of the court or judicial officer, etc. The key notion is making a claim. The key notion of an originating process is that it makes a claim to a remedy. So what we're talking about here in this short lecture is how to move a court to consider a claim for a remedy. Another definition of a proceeding, according to the Australian Law Dictionary, is that it's any action, cause, or matter. Specifically, a proceeding means any matter in the court commenced by a writ or originating motion or is otherwise provided, etc. Proceedings may be either civil or criminal. Civil proceedings are typically instituted by and then certain documents. Remember that things happen before proceedings are commenced, and indeed the previous few videos have considered those things. One of the first things that will happen before a person commences proceedings is that they should instruct solicitors unless they're acting in person, and solicitors should make sure they comply with their ethical obligations before commencing litigation. An important part of compliance with our fundamental obligations as practitioners is to gather enough information to be sure that the claim is a legitimate one. You consider causes of action and remedies, you consider equitable doctrines, you comply with your duty to confine the issues where appropriate, and you pursue a settlement. Ideally, you don't commence proceedings unless you've exhausted all dispute resolution alternatives or ADR alternatives. Why is that? Well, we have the overarching purpose in Section 37M of the Federal Court of Australia Act and the case management principles expressed in the Rules of the Supreme Court 1971, each expressing the importance of efficient dispute resolution. And to be honest, dispute resolution through litigation in a court isn't going to be as efficient as negotiating a deal. Another thing to consider before commencing proceedings are any applicable limitation periods. You don't want to commence a proceeding out of time. And you should also consider which court to sue in. In order to do that, you should consider which courts would have jurisdiction, both subject matter jurisdiction, personal jurisdiction. You should also consider whether the matter, if brought, would be in federal jurisdiction. And after considering those options, you select a court which would be best to achieve an outcome for your client. Prospects of success, I mentioned them before, but they are essential to consider before you pull the trigger on commencing litigation. If the claim would have no prospects of winning, then its commencement would be an abusive process, meaning a waste of the court's time, liable to be stayed, and it could expose your client and even yourself to adverse consequences. We'll learn more about costs later. So once you've gone through those steps and you want to commence a proceeding, you do it with what is called an originating process. Basically, commencing proceedings involves filing a document. That document is then issued by the relevant court, making it official. In a generic sense, the term originating process is that document. It's the document that starts it all off. Originating process also has a technical meaning, but it's used generally by courts and by textbooks to describe the court document that starts litigation. There's more than one kind of originating process. The correct one depends on the court you're going to and they have different names within the federation, unhelpfully. For example, the way you start litigation in the Supreme Court of WA is different to how you'd start in the federal court, and is different again to how you'd start in the Supreme Court of New South Wales. In order to determine the appropriate form of originating process, you need to look at which court you're suing in, so make that choice of forum, and then second, characterize the type of proceedings, because there are different kinds of originating process for different kinds of proceedings. Actions, for example, are commenced one way, whereas certain other matters might be commenced another. How do you figure out which originating process is the correct one? Well, the answer, like many procedural questions, is to be found in the rules of the court and any practice directions or practice notes. That's why practicing your navigation of those sources is fundamentally important to being able to apply procedure in practice. Another point to emphasize is that form here is particularly important. By form, I mean getting the correct form. There's a Form 1 and a Form 2 for the Supreme Court, for example. But in addition to getting the correct form, I mean formatting. That is, making sure the margins are right, making sure the parties are named correctly, getting all the little details correct. And that's why lawyers emphasize the importance of attention to detail for law graduates. Getting those little details right is important, because if you get them wrong, it could render the proceeding an irregularity, having negative consequences for the client. An originating process is a type of process. Originating, the adjective, means what it sounds like. It starts something, whereas a process is a fancy term for a document issued or filed with a court which requires a person to attend before the court. A writ is an example of a process, but there are certain process which are not originating in character. A good example of that might be a subpoena. You might subpoena a person who isn't party to the litigation to produce certain documents. That doesn't necessarily mean you're suing them, but it's compelling them to do something. There are various other processes which are relevant to civil procedure. Those that we're focusing on at this stage in our consideration of the subject are the originating process. So this is how it used to look in practice. That is, this is how you used to get an originating process. First step would be a solicitor or the litigant in person, if they can't afford one, prepares the OP, the originating process, which is basically a draft document in a special form. That draft document is then printed in several copies and then taken to a physical office, the registry of the relevant court. The person who takes those copies down pays a fee, and then the court will affix a seal, which in the early 21st century involved physical stamps and dating and signatures. The court would keep a couple of copies, or at least one, but a sealed copy, the sealed originating process, often a writ, would then be returned to the person who filed it, which is usually an employee of the solicitors for the plaintiff. And the reason why a copy was returned and that copy was sealed was so it could be served. Service, you already know about, is important to personal jurisdiction, but it's a topic worthy of its own consideration a little later. Anyway, the registry retains a copy of the originating process. And it's important to note that it's not cheap to do this. These days, it costs over $3,000 to sue a corporation, but that figure changes regularly, and by the time you're listening to this video, it might have already changed. So it's really important in practice to always look up the current version of the applicable rules, regulations, or directions to make sure you've got the right fee. The process is similar these days, although it's become online, following common sense. And this is, since I started my career, this has changed. So these days, if you look at the consolidated practice directions and practice direction 1.1.3 of the Supreme Court, you'll see that the e-courts portal, which is just the online system of the Supreme Court, should be used to file most court documents in the General Division of the Supreme Court, and also to pay associated fees. Whereas back in the day, I remember having to take down checks, which is weird. And if the number on the check was wrong, you'd get in trouble. These days, you can pay it all through the portal and you don't have to run to the court, which is probably good. I remember getting stitches, having to run in a suit. I was sweating everywhere. It was gross. So this is much more convenient. The Federal Court has an equivalent e-lodgement portal. If you check out the Technology and Court Practice Note of the Federal Court, you can get more details on how it's done in practice. And this is a rough macro model of the first steps in litigation. I've gone through a rough model of litigation before, but this is how it looks if you're going to sue someone in a typical action. The plaintiff first will undertake those pre-commencement steps we went through before. The plaintiff then will have the originating process issued by the court, which involves drafting a document, then having it filed so the court can issue the official version. Technically, the originating process doesn't exist until the court issues it. The plaintiff then has the issued originating process served on the defendant, that is, service occurs, and then the defendant will respond to being served. The typical way a defendant will respond is through entering an appearance, although there are other things that might be done. So the skills for lawyers to develop, these are the things that clients pay for, are these. First, given a set of facts, where should the plaintiff sue, that is, which forum, and what originating process is the correct one? How, in a practical sense, do you get the originating process to be issued? Once it is issued, how do you effect service? That is, how do you serve the defendant properly? And from a defendant's perspective, given a set of facts, how should a defendant respond to service? The answer to these questions involves applying basic legal research skills and involves consulting the rules of the applicable court, the practice directions of the applicable court, and engaging in a bit of deductive reasoning with the aid of leading commentary in cases of ambiguity. That's been a high-level overview of commencing proceedings.